I have a question for you. When your medical malpractice case goes to trial, can a jury determine that your doctor was careless and that his carelessness was a cause of your injury, and yet give you absolutely nothing in terms of damages? Can they do that? Is that possible? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, here's the scenario. You brought a lawsuit against your doctor claiming that he violated the basic standards of medical care and as a result caused you significant harm and injury. The doctor, on the other hand, turns around and says, hey, I did nothing wrong. Why are you suing me? And if I did something wrong, well, guess what, Mr. Patient? So did you. And then he says, listen, if I did something wrong, whatever I did not really cause or contribute to your injuries. And maybe if it did, well, guess what? Your injuries really are not as bad as you claim them to be. So those are the typical defenses that we see in these medical malpractice cases. So now, what does that mean for you? It means that your case is likely going to trial. It means that they're not going to negotiate, and they're not going to try and get into settlement discussions with you. So now it takes 2 to 3 years for you to get to trial here in New York. And during the course of your trial, you put on all of your testimony, all of your medical experts, all of your witnesses who are coming in to support your case. Likewise, the defense does the same. So now, at the end of the case, the jury is told to go back and deliberate, to reach a verdict, and they're given a series of questions that they have to answer. The first question concerns liability. Who, if anyone, is legally responsible? The second question concerns what we call causation. Was the doctor's wrongdoing a cause of your injury? And the third question that they have to answer focuses on damages. And there are different types of damages, from what we call economic damages, things that can be calculated, and non-economic damages like pain and suffering, which cannot be easily quantifiable. So now, the jury ultimately comes to the decision that yes, your doctor was careless. He violated the basic standards of medical care. And now they go on to the next question, which is, was the doctor's carelessness a cause of your injury? And the way it's phrased on the jury sheet is, was the doctor's negligence a proximate cause of your injuries? Yes or no? If the answer is yes, now they must go on and answer the next series of questions, which is how much money you are to receive for each element of damages that you are claiming in this case. Imagine this. The jury has determined that yes, your doctor was careless, and yes, his carelessness was the reason, was a cause of your injuries. But now, in terms of damages, they decide you are entitled to nothing for the suffering and the pain you endured for the years from the time of the malpractice up until trial. The jury also inconceivably comes to the conclusion that you are entitled to nothing from the time of trial for the next 30, 40 years of your lifetime. The jury also inconceivably determines that you are entitled to zero for all the years you have been out of work because of the injuries you suffered from the doctor's carelessness. And they also determine that you're not entitled to your medical bills and that you're not entitled to any amount of money for any element of damages you're claiming. Does that make sense? Is that even possible? The answer is, yes, it's possible, but it is inconceivable. So now when the jury reads their verdict, everybody in the courtroom is totally shocked. They see that, yes, they determined that your doctor was careless. Yes, his carelessness caused your injury. But now everybody's waiting to see how much money they have given to you for all the harms and losses and damages that you suffered. And now they say zero, zero, zero. And you're wondering, what? How is that possible? How is that even possible that a jury of 6 members of the community determined together, collectively, that you were entitled to absolutely nothing? Well, I will tell you, it is highly unusual for that to happen. In order for the jury to come back with a decision and say, hey, you're entitled to zero, means that something significant happened during the course of trial, in all likelihood, with your credibility. Maybe the jury determined that you were not believable. Maybe the jury wanted to send a message to your doctor that, hey, yes, you were careless, and yes, we recognize that your carelessness caused this patient harm. But now, they heard all the testimony. They heard that you have permanent and significant long-term injuries and disabilities, and they gave you nothing? Well, now there's a credibility problem. Now there's an inconsistency in the verdict, and now it has to be fixed. And there are only a couple of ways to fix that inconsistency. The first way is to have your attorney, and your attorney will do this immediately, he's going to ask the judge to poll the jury. And all that really means is the judge is now going to ask each juror whether this represents the reality of their verdict. Is this what you intended to say? Yes or no? Juror number 1, on the question of how much money the patient is to receive for her past pain and suffering, how much did you award? 0. Juror number 2, how much? 0. And now they go down the line, 0, 0, 0, 0. That's a problem. And for the next element of damages, juror number 1, how much did you give them? 0, 0, 0. It's not a problem with transcribing what the jury actually intended with what was actually written down. So now the judge has a problem. The attorneys and the judge all know that there is clear evidence given to support your injuries and a significant damages verdict. But for whatever reason, the jury has decided not to give you any money. Now, the defense will likely be totally thrilled, and he's going to do everything possible to try and make sure that the judge keeps that verdict as it is. Your attorney, on the other hand, is going to stand up and say, Your Honor, I object to this verdict as being against the weight of the evidence. It is inconceivable that the jury reached that part of the verdict, and now they did not give my client any money whatsoever. Now I'm going to ask you to throw out the damages portion of the verdict. And the judge has to make a decision. There's a very good chance the judge is going to say, listen, get the trial transcript, and now in formal papers, what we call a post-trial motion, I want you to give it to me, give me the transcript, together with a legal brief with all the research about why you believe that part of the verdict should be thrown out. And now he'll have time to do that. Then he'll give the defense time to reply. And then the judge will have additional time to do his research and come to a conclusion about whether or not you are entitled to a verdict in your favor. Regardless of what decision the judge makes, in all likelihood the defense is going to be unhappy. And in all likelihood the defense is going to appeal that issue and say this is ridiculous. The jury reached their decision that this patient is to get nothing. But on the other hand, where the evidence clearly supports an amount of money, after the jury has decided already that yes, the doctor was careless and the carelessness caused your injuries, now they are obligated to give you an amount of money. How much is a different factor, it's a different issue. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you've not yet started a lawsuit because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.